Hello and welcome everyone. Thanks for joining us. This is the Talking Animals Law and Philosophy series. My name is Raphael Fizel. I am the Executive Director of the Cambridge Centre for Animal Rights Law. I see a couple of familiar faces or names in the participants list, but also some new ones. So welcome to everyone, especially those who are here for the first time. I'm briefly going to just say a few words about how the format of these events works and looks like. We're going to start with a presentation by our speaker that will last for about 30 to 40 minutes. And we will then move to a discussion and Q&A part where everyone is very much welcome to participate. We will be recording the presentation bit of the event. So you can later watch it on YouTube or our website or send the link to a friend if you like. We will not, however, be recording the discussion bit, so you should feel free to just come in with any sorts of comments and questions you have. The event will end at 6:30 p.m. UK time, so people can have their dinner or lunch, or depending on the time zone they might be in. If you would like to participate in the discussion bit that I just mentioned, could I please ask you to use the raise hand function? You will find it under the reactions button at the bottom of your Zoom app. I can then go through the different raised hands and allow you to ask your question or make your comment directly to our speaker. If you cannot locate the raise hand function, you can also use the chat function instead. Okay, and until that point, I will be muting all the microphones. With this out of the way, it is now my pleasure to introduce our speaker today. And we have the great honor of having Paula Sparks with us. Paula is a visiting professor at Winchester University, where she teaches an animal law module. Paula is the chair of the UK Centre for Animal Law, ALAW for short, as I'm sure many of you will know. ALAW is a charity whose vision it is to create a world where animals are fully protected by law. In her role at ALAW, Paula oversees the program of animal law events, publications, advocacy, pro bono, as well as student outreach, and she works closely also with animal advocacy groups, lawyers, and academics. Today, Paula will be talking to us about the Animal Welfare Sentience Act 2022, which I think received royal assent just last month. So this is very topical, and it has the intriguing subtitle, Stating the Obvious or an Obvious Step Up. And I'll be really curious to hear what Paula has to say on this. Paula, thanks so much for being here today. The floor is yours.
Thank you very much, Raphael, and thank you to you and Sean for inviting me to speak today. I'm going to share my screen if I can. I'm still as a panelist. Will I be able to share my screen from here, Raphael?
Yes, you should be.
Yep, okay. Let's go back to my first slide. There we go. And so this is the title, Stating the Obvious or an Obvious Step Up. And I think that's because some of the debate has focused on, do we need to actually recognise sentience in law? Are we not stating the obvious that animals are sentient? Do we need to enshrine this in legislation? Or is, in fact, this legislation going to produce something that is practical, that is meaningful, and is going to advance the animal law landscape? So I just wanted to start by just setting out the landscape by saying, what is sentience? Because we sometimes assume that we understand the meaning of sentience, but actually I wanted to start with a scientific explanation that was given by Dr. Jonathan Birch, giving evidence to the EFRA committee who were examining the bill. So I'm just going to play this short clip to you.
Dr. Jonathan Birch, would you like to have a go at that, please?
Thanks. Yes, that is a broad question. Sentience is the capacity to have feelings. This can include feelings of pain, pleasure, joy, sadness, comfort, discomfort, hunger, thirst, warmth. Two things to note about that, I think. Firstly, that it's not just about pain. It's the capacity to have feelings, but of course, feelings of pain and suffering do have a particular ethical significance and thus a particular significance for animal welfare law. And I think the second thing to note is that it is just the capacity to have feelings. It's not the capacity to reflect on one's feelings. It's not the capacity to understand the feelings of others. These are more sophisticated capacities. Sentience is just about having these feelings. Now, how do we look for it scientifically? Well, of course, we can't directly observe the feelings of other animals, but what we can look at is a battery of cognitive, behavioral, neuroscientific indicators of sentience. In this area, pain has been particularly important, and I think rightly so, because of its special significance for animal welfare law. And lists of indicators of pain have been developed that look at the sort of manifestations pain is likely to have in creatures that feel it. So it's partly about looking at the neural pathways and looking for the presence of nociceptors and for the presence of integrative brain regions and for the presence of connections between them, where a nociceptor is a specialized receptor for noxious stimuli. But it's partly also about looking for behavior. For example, is there behavior such that if an animal is injured, it will develop a lasting aversion to the place where it received the injury? Can that then be modified by something like a local anesthetic or an analgesic so that the animal no longer seems to be experiencing the pain? And then even more striking evidence would be, does the animal learn to prefer the places at which it can access the anesthesia or analgesia when it's been injured? So that's just I won't give a full account, but I've given you a general sense of the sorts of indicators we can look for to develop a robust scientific case for sentience.
So I think two things to note about that. Firstly, that sentience is not just about the capacity to feel pain, to have negative effects, but that it's also a recognition that animals have the capacity for positive experiences. And this is important when we consider how that translates into animal welfare law, that it's not just about protecting from negative states such as pain, but also how we promote positive welfare duties. And this is something that Ian Robertson in New Zealand, for example, talks about in relation to sentient animal law. And the other noteworthy factor, I think, that comes out of this short clip is that there is always a challenge to identifying sentience in species who we don't have experience of ourselves. We don't have the same experience as non-human animals, so we can never truly know their experiences. So we have to have a robust scientific framework in order to come to conclusions about animals' sentience and whether animals are sentient and to what extent animals are sentient and how we regard that. And I thought that was a very helpful introduction to the animal welfare science around determination of sentience. Oh, going past there. So if we start back from the beginning, why have we come to the position where we're even talking about enshrining sentience in law? This is because we had, as part of the European, our entry to the European Union, the European Union had already recognised that animals are sentient through Article 13 of the Treaty of the Functioning of the European Union. And I've put the full article up on the slide. And essentially what we draw from this is that the article acknowledges, as it says here, since animals are sentient beings, that in relation to certain policies which are set out here, so the union's agriculture, fisheries, transport, internal market, research, and so on, that since those animals are sentient beings, that the union and the member states should pay full regard to their welfare whilst respecting legislative or administrative provisions and customs of the members as a countervailing policy consideration. So what Article 13 does is that it recognises that animals deserve special protection by reason of their sentience, that they are not simply inanimate items of property, agricultural goods. And secondly, and importantly, it places a legal obligation upon both the union and member states to pay full regard to the animal's welfare requirements when formulating and implementing policy in those areas listed. Now, why only those areas and not all areas of policy? And that's because those are the areas that relate to the European Union's common functioning. And this is why you don't see the member states being challenged so much about Article 13 duties in relation to other areas, because it relates to those areas where the European Union has the responsibility for making policy collectively on behalf of those member states who both feed into the policy and then are bound by the policy when European laws are made. So why was it so important to enact Article 13? Well, the status of animals before that was as goods or products, and animals, for example, used in agriculture would be regarded as agricultural products. In order to give competence to the European Union to make animal welfare laws and make animal welfare legislation, it was important to have that recognition within the legal framework, the primary law setting up the EU, that animals, that this was an area of competence for the European Union. What happened with Brexit was that Britain faced no longer being part of the EU legal framework, and that meant not being bound by Article 13. So when the withdrawal bill, which brought across en masse the European laws, retaining those as Britain left the European Union, Caroline Lucas for the Green Party proposed an amendment that would bring Article 13 across as it was written. That was whipped against by government, and essentially the response to that proposal was, well, we already know that animals are sentient, that's why we have animal welfare legislation. If we thought animals weren't sentient, then we wouldn't obviously have enacted the Animal Welfare Act of 2006 and other legislation protecting animals' welfare, because there would be no need, we wouldn't know that they were sentient. So this was the initial response. It wasn't felt that it was necessary to enshrine in law the fact that animals were sentient. Now, the government received quite a bit of pushback on this. There was a lot of media attention, and there were media reporting that probably didn't really do justice to the issues. Lots of reports, government doesn't recognise that animals are sentient. You know, it's a much more nuanced argument than that. And in response to that, we at A-Law put out a briefing paper that tried to distill these issues. But it did result in a government U-turn. The minister at the time, Michael Gove, announced that yes, the government would recognise that animals are sentient. And what was published was this bill, the Animal Welfare Sentencing and Recognition of Sentience Draft Bill. So this was published as a draft bill, and that is something that happens more often on the parliamentary process now, that you sometimes have these draft bills published, and they give more scope for input at an earlier stage from people feeding in their thoughts on the proposals put forward in the bill. And this simply recognised that animals were sentient and required that ministers of the Crown must have regard to the welfare needs of animals as sentient beings in formulating and implementing government policy. And so you may well think, well, that's very straightforward. It replicates as closely as possible Article 13. Job done, it's going to pass very quickly, it's had cross party support, but it was not to be. The bill was subject to scrutiny at a very early stage by the EFRA committee, and at the same time the government also published a consultation, and you can see the consultation questions here in this slide, raising issues such as, should sentience be defined? If so, how do we define it? What about the term animal? Should that be defined? And if so, how? And how should the welfare needs of animals be defined? What definitions should be used? Should there be a list? Should this apply to all policy areas or just certain policy areas? What about the term should have regard to? Should that be full regard or due regard? What do people think about this? So all these questions were being raised in relation to what seems a very simple bill. The EFRA committee was very critical of the bill. They described it as hastily drafted. And one of the major concerns of the committee was that it presented too high a risk of judicial review. They felt that by simply formulating a duty to have regard to animal welfare when formulating and implementing policies could mean that that was hijacked by people who had other agendas, no real concern about animal welfare. It may be in an area that was completely unrelated to animal welfare, but because the government hadn't ticked the box to say that they had taken into account animal welfare, that they would be subject to judicial review, and therefore accountability was being moved from Parliament to the courts. And there was a lot of discussion about that in the oral evidence phase that predated the report. I personally think that the risk that risk was not as high as perhaps it seems. If anyone's actually practiced in the area of judicial review, they will know how difficult it is to bring a case and how many barriers there are to be overcome, and actually that it's not an area where the courts have a huge amount of discretion when it comes to looking at decisions that have been made. It's really about process. But nevertheless, it caused the government to go back to the drawing board. What happened then was sentience was decoupled from sentencing, which was the other part of that draft bill. And the policymakers then had to grapple with this question. Yes, we can recognise in law that animals are sentient by simply stating that animals are sentient, but how do you formulate a duty to take into account their welfare needs in the policy making process? What mechanisms do you use? What mechanisms are available? And how do we do this whilst minimising the risk of judicial review that people were so concerned about? And there are a number of mechanisms that were being discussed that have been put forward. So the four main ones I've presented here, so perhaps an animal welfare commission, an animal welfare commissioner, prospective animal welfare impact assessments, or simply an annual duty upon DEFRA or the DEFRA minister to report to Parliament retrospectively about how Parliament had, or how the government had taken animal welfare into account over the last term. So a little bit about this. Animal welfare impact assessments. I know Stephen McCulloch here, who is one of the big supporters and propounders of animal welfare impact assessments. And I think these are great. They're analogous to environmental impact assessments. They can directly assess prospectively the welfare impacts of policies on sentient animals, including both their negative and positive impacts. So positively, would they impact or would they have a negative impact? So having a formal mechanism to assess impacts before enacting policies or laws that may impact upon animals' lives would be perhaps the highest of the mechanisms that give the most protection. Having an animal welfare commission or a committee, an independent body with scientific and ethics, animal welfare expertise that can give strategic advice to government, was a recommendation by the Centre for Animals in Social Justice, would again be another mechanism that could be helpful. Or having a commissioner who would be able to cross different ministerial departments or government departments and raise issues relating to animal welfare would be another good positive mechanism. Having an annual duty to report to Parliament is the weakest, I would suggest, of those options, because there's no opportunity to consider impacts pre-implementation. It's about looking back and saying, we could have done things better, we could have done things differently. And hopefully that would fulfill a function in learning for the future, but it doesn't actually give a chance to intervene in a way that would avoid those impacts. In New Zealand, we know that legislation has established a National Animal Welfare Advisory Committee, and that's the committee that would advise the government as to policy impacts, and that also has ethics expertise built into the process, very positive. There's also the Dutch Council on Animal Affairs, which has a remit which includes free living animals as well as companion animals and animals used in agriculture, again very positive. And closer to home, the Scottish Animal Welfare Commission, which is tasked with providing scientific, ethical and other advice to government about policy impacts, been very useful. You can see here their role in examining how welfare needs of sentient animals are being met by devolved policy, looking at legislative and non-legislative routes to further protect the welfare of sentient animals, and examining research requirements to provide an evidential base for future policy development. So policy is, the idea is much better informed both by science and by ethical input. And you can see here the good, I think, and positive aspects of the Scottish Animal Welfare Commission. There is a chair who is a professor of animal behaviour and welfare. They have 12 commissioners recruited through an open advert procedure, and they've published their work plan. And if anyone wants to go and have a look at that, I would really recommend it. They've been doing some excellent work in Scotland. So what we did end up with, faced with these options, was the Animal Welfare Sentience Bill introduced in May 2001. And this essentially provides that the Secretary of State must establish and maintain a committee called the Animal Sentience Committee. So this is the closest analogy to the commission type proposal. It also provides that when any government policy is being or has been formulated or implemented, the Animal Science Committee may, so it's a discretionary power, produce a report containing its views on whether and to what extent the government is having or has had all due regard to the ways in which the policy might have an adverse effect on the welfare of animals as sentient beings. Now, looking at the face of that, what you would pick up from that is a negative in that it's a duty to have regard to the way in which a policy has an adverse effect. Now, we've talked about sentience being about positive and negative experiences. When the Minister, Lord Benyon, was talking about this in the Lords, he did clarify that adverse effects means whether that's an adverse effect negatively or positively on animal welfare. And I think that's worth bookmarking for the future, that adverse doesn't necessarily mean only negative animal welfare experiences, and it shouldn't do, because we're also looking at how policies might have a good animal welfare impact. The third duty is that where the Animal Science Committee publishes a report, the Secretary of State must lay a response to the report before Parliament within 3 months. So this is what the Act intends, which is bringing accountability to Parliament rather than to the courts. And this is the only direct duty upon the Minister, and that is to publish a report in response to any report that the Animal Sentience Committee may publish. This is quite a long excerpt, so I may not play it all, but actually I just wanted to just set the scene a little bit in terms of how this bill was presented in Parliament, because I think this is, it's very positive to see the bill presented in this way, which really focuses, I think, on animals and the interest of animals as a British value and something of importance to the government. So I'm just going to play, I may not play all of it, but I'll play some of it.
My Lords, I beg to move that this bill be now read a second time. It is a privilege to open this debate. Today in this House, we are opening a new chapter in this country's proud story of protecting and promoting animal welfare. I am proud, as I hope your Lordships are, of the UK's reputation as a nation of animal lovers. It was the UK which introduced the world's first animal protection law, the Act to prevent the cruel and improper treatment of cattle, and that was in 1822. We've made a lot of progress in the 2 centuries that have followed. We've improved the conditions in slaughterhouses in 1875 and passed the Protection of Animals Act in 1911. We established a world-leading system for regulating scientific experiments on animals in 1986. And in 2006, the Animal Welfare Act introduced powers to protect all kept animals in England and Wales. There's never been any question that this government believes that animals are sentient beings. We are now recognizing this formally in domestic law and introducing a proportionate accountability mechanism to help reassure people that central government policy decisions take this into account. The government's manifesto promised that we would bring in new laws on animal sentience. Parties represented on the benches opposite made similar pledges. This bill is our opportunity to honour that commitment. The bill proposes 3 things. First, it proposes a recognition in law that any animal with a spine, any vertebrate, is sentient. Sentience is about animals having feelings, both positive and negative, like pain or joy. The scientific community is continually improving our knowledge of the sentience of different species. There is clear evidence that animals with a backbone, vertebrates, are sentient. The bill gives the Secretary of State a power to extend this recognition to any invertebrate species in future, for example, if evidence of their sentience becomes clear. Secondly, the bill establishes a committee, the Animal Sentience Committee, tasked with the reporting on whether individual central government policy decisions have paid all due regard to their effect on the welfare of animals as sentient beings. The Animal Sentience Committee will have the right to roam across all central government departmental policy decisions, and this includes decisions relating to policy formulation and to policy implementation. The committee's findings will be made public and its reports will make recommendations. Finally, the bill obliges the relevant minister to respond to each report from the committee through a written statement to Parliament. And that statement should set out the minister's response to the committee's recommendations. Taken together, the provisions of this bill create a targeted and proportionate mechanism for holding the government to account on animal welfare. The Animal Sentience Committee's reports and the ministerial responses to them will support Parliament's scrutiny of how central government policy decisions pay all due regard to the welfare of animals as sentient beings. My Lords, the introduction of this bill fulfills a key manifesto commitment, as I've already said, and it will further the UK's position as a global leader on animal welfare. Now that we've left the EU, we have the opportunity to remake laws and to go further to promote animal welfare. Importantly, there are no policy exemptions in this bill. It covers vertebrate animals in all settings and in all central government policy areas. If you accept, as this government does, that animal sentience is a matter of fact, then you must properly consider animal welfare in relevant decisions that you make. By enshrining sentience in domestic law in this way, there will be further reassurance that government policy decisions have been made taking into account the fact that animals have feelings.
So I'll just stop it there, and you can, you can watch the rest of it in your own time. But I think it gives you a flavour of how the bill was introduced, and I think it's very positive to see animal welfare being presented globally as something to be proud of and something that is a good policy objective. Let's move on to the next. The bill didn't have an easy run, and again, I'm just taking some comments from Lord Herbert, and again, I probably won't play the whole thing, but it gives you an indication, I think, of the flavour of the opposition to the bill and some of the concerns about the bill on the other side.
I think we need to consider a number of questions as we examine this bill. The first is to distinguish very clearly between animal rights and animal welfare. I would submit that every one of us is subscribed to the principles of animal welfare, that we should treat animals humanely, compassionately, properly. The idea that animals have rights which are in some way akin to human rights is much more problematic, and obviously so. Most of us, not all, who agree that animals must be treated properly and humanely, who feel very strongly about that, also eat animals, probably support the use of animals in scientific research. And the distinction between animal rights and animal welfare is important when it comes to the consideration of the difference between wild and domestic animals, because it is obvious that a domestic animal under our control deserves, for instance, that it should be watered and fed properly. And if we don't do that, then we break the law and rightly can be held responsible for such cruel treatment. But a wild animal, even if it is on land that a farmer owns, that farmer can have no responsibility for feeding and watering that animal. It is not under his control. It is only when wild animals are brought under domestic control or the control of individuals that they deserve the protection of the law. Instantly, we see that the doctrine of animal rights is unhelpful in guiding us as to how we should treat animals. Secondly, I believe that we need to advance the protection of animals on the basis of principle and evidence, and ensure that we can, as far as possible, detach what is often very powerful emotion from the debate. Because the exercise of emotion in any aspect of law making can lead to bad law, where parliamentarians are doing things because in the worst case they think it is popular, or because they are driven by their own sentiment in the matter. We have to be more careful and forensic than that, because there are competing interests to be balanced. And my lords, this chamber above all chambers needs to exercise that.
So this was a theme that came up more than once, that this was a bill that was concerned with animal rights, and was being, the legislative process was being hijacked in some way. I'll play you two very short clips.
Lord Moyton. My lords, the noble Lord Hannon of Kingsclere asks what the purpose of this bill is. We all know what the purpose of this bill is. It is to advance an agenda for people who believe in the existence of animal rights and to embed them at the heart of government, bossing everybody about.
And again,
Important issues. Most people have feelings for animals, but there is a small lobby of activists who rarely vote Conservative or indeed vote Labour, I should say, pushing an animal rights agenda. They are not mainstream. They represent only themselves. Peter, the people.
so I think what's really interesting here is that, and I give these clips an example of some of the flavour of the debate there was at the second reading in the House of Lords. It's the very people who are arguing, and we hear this a number of times, that decisions relating to animals are driven by emotion. They're driven by sentience, sentiment, popularism. Is that in relation to this committee, it's the very opposite that's true, that we need to inject proper ethical framework and scientific advice into our decision-making process. That in fact, the emotion and the sentiment is seen in the other direction from people who don't want or are worried about the landscape changing, and that we have these comments about animal rights. I don't feel that the term animal rights as it's used here is particularly well understood. And I think actually it's making the case for what we need is properly ethically informed decision making. And that's what the committee should bring to the process, as well as animal welfare science, looking at some of the ethical decisions around how we treat animals, whether it's in relation to animals used in agriculture or the animals around us. That it shouldn't be presented in this polarized way of animal welfare and animal rights. But I thought it was interesting to see some of the debate, and we can see that there are a number of concerns that were raised throughout the debate at the second reading, particularly about the impact upon the ability of people to engage in slaughter for religious reasons. And we did end up with a very late amendment around that, recognising that there should be a weighing up process. Again, I'm not actually sure that that's really necessary, because all the committee is doing is providing advice to the government, and it's really for the ministers to weigh up different competing policy considerations, as they would do in any context. I'll zip through the rest of my slides. I don't want to take up too much. I've already gone past the 20 or 30 minutes, so I'll be another 5 minutes. So we've got two aspects of the bill, or this new law. You have the symbolic recognition that animals are sentient, and I do think there is a symbolic merit in recognising that in law. But the second question is, do we actually need a mechanism to recognise and to give effect to a duty to have regard to their welfare needs? And again, I'll just play you a minute of Stephen on this, because he addresses this question head on.
So the question really is, do we, in terms of, is there a need for an animal sentience committee? How does UK government policy making currently account for the interests of sentient species? And this was actually my research question effectively in my doctoral thesis a few years ago. And it may surprise people, because the UK is a global leader in animal welfare, and many people have sort of referred to that in the Lords and other debates. But actually, the UK policy-making process in a number of ways excludes and undervalues the interests of sentient animals. And really, that's what this bill is for. And I'll just give you one example of how that's done. So the Treasury Green Book, which all of you will be familiar with, the central government guidance on appraisal and evaluation, it was updated in 2020, and it runs to 152 pages. To quote the book, it's the central book on how to appraise policies, programs and projects in central government, and it essentially provides advice. If you search within that book, you won't find one mention of animal. You won't find one mention of animal welfare or animal sentience. And in many other ways, which I won't go into, animals are excluded in policy making. So there is parliamentary scrutiny, there are consultations.
So I'll just leave that there, but I thought that point about the agreement was actually really interesting. It was certainly eye-opening for me when I listened to the evidence live. You would have heard Lord Benyon refer to vertebrate animals really importantly through the course of the parliamentary proceedings, and an amendment was laid down to extend that to cephalopod mollusks and decapod crustaceans, who are also now recognised as sentient animals. That's hugely important. It doesn't change the substantive provisions in the Animal Welfare Act, but it certainly creates more pressure on the government to amend the Animal Welfare Act, as it has the power to do under secondary legislation, and to look at other aspects of the legislation protecting animals at the time of slaughter and during transport and husbandry. There's a little clip here which I won't take you to because we're running short of time, but this is from Dr. Jonathan Birch, who gave evidence to the EFRA Select Committee, and it was the basis of, it was the report from LSE that he led that really gave the underpinning for the expanded definition of animal to those species. So some of the negatives, just very quickly, okay, there's no formalised process for animal welfare impacts assessments, but there is a prospective process to take into account animal welfare impacts. The only duty on the Minister is to report to Parliament on receipt of a report. The committee isn't independent from government. There's a lack of statutory detail in the legislation about the composition of the committee. In fact, the operative provisions haven't been brought into law yet. I'm waiting to see if they will be shortly, hopefully. There isn't a commitment, as you usually see in a schedule, to enact the full composition and so on, detail in relation to such a committee being set up. But the positives, and I do think there are many, is the fact that, yes, we do have the symbolic recognition of sentience in law. The invertebrates, some invertebrate species have been included. I think that's a big positive. There is a mechanism to better inform policy about animal welfare. So the big thing here is that it's a structural change, and that's what we need with animal welfare, not only the incremental development of animal law, but we need our animal welfare, but we need to see this type of structural change. It isn't simply a retrospective analysis of what could have been improved. We're seeing something that is prospective. So I think there are some positives as well. I've just put up some further reading if anyone wants to look at any of our position statements or policy documents, and some of the government documents there as well. So, you know, feel free to have a deeper dive in your own time. But thank you for bearing with me. I know I've gone on 45 minutes, a bit long, but it's a lot to cover. Thank you.